May it please the court. I'm Eric Godding, and I'm going to be discussing the radio frequency, or RF, issue, and I'd like to reserve 1 minute. Montgomery County's concern is what the FCC has yet to say. In response to rulemaking comments that the FCC's RF exposure standards may not reflect the current safety research or account for this new 5G environment that we're going to see in the coming years, and that the FCC must resolve those issues before accelerating the siting and the operation of these 5G small cells on public rights-of-way, the FCC offered a single sentence. It said it disagreed with any concerns that Montgomery County or others have.
I guess the issue which has been raised in the 28J letters is mootness, given the completion of this rulemaking, which had begun much earlier. So why don't you address that?
So the burden in this court is heavy on the FCC. It has to show that there's no possible way for this court to give any relief. And so in our case, we're asking the FCC to explain, in the context of this order, why RF is either irrelevant or why it thinks it's important and how it's going to resolve this issue.
Why shouldn't you now? I mean, your complaint originally in the briefs was that the FCC should have completed this rulemaking.
Yes.
During the pendency of this appeal. They have now done that, and so why would you not raise any challenges you have to that rulemaking in a separate petition?
I would disagree that they have done that. They've done two things in those 6 pages where they close out the NOI. They talk about cell phones, which are not small cells, and then they have some conclusory statements that the record doesn't show that they need to update these RF standards. But nowhere in those 6 pages do they ever discuss the 5G environment. They don't discuss densification. They don't discuss the use of millimeter waves.
Yeah, that may be,
Right.
But why wouldn't the appropriate process here be for Montgomery County to now challenge that other rulemaking? Because the thrust of the argument initially was they just haven't completed the rulemaking, but now they've completed it. So why wouldn't you may have good arguments against that rulemaking, but how do we dispose of them in this case?
Because we didn't get the relief. If we have to go back to court and take another year to litigate this, we're not getting the relief that we want, because it's our position that they actually haven't addressed the issue. Montgomery County wants to be able to tell its citizens it's putting these 5G small cells on its property. And the citizens are asking, is this safe? Or can we walk on our sidewalks? And if we have to go back and litigate for another year, that's a year that the carriers and the FCC is allowing these to be deployed. And so we have the evidence in the record showing that these may be dangerous, maybe they're not. But we don't have the answer to that question. And I think is...
We don't have the later action before us.
But they've raised the mootness issue, so I think the court now has the obligation to decide it. So, but I think on its face, I don't think the court has to do a lot of work.
Review the merits.
You don't have
to. To me, you're really disagreeing with the merits of that.
No, we're not disagreeing with the merits. I think on its face, they didn't address this issue. I don't think the court needs to dig into the record or anything. I think on its face, it literally decided not to address the issue that we asked, which was to clarify, is this a potential risk or isn't it? And so we can go back to our citizens and we can take whatever steps we need to take to deal with these new small cells. And so I think in the context, I think our case is rather simple. It's kind of an APA case. In this order, our order, not the one we were just talking about, they don't explain their decision. They had a single sentence. Despite the fact that you have this huge record of concern, of studies, of research.
So, counsel, in the other matter, the matter that's closed, is that subject to appeal? Have you taken a notice of appeal on that one?
Yes.
Being arbitrary and capricious? Is that pending, and where is that pending?
So there are 2 cases, one here in the Ninth that I know of, one here in the Ninth and one in the D.C. Circuit.
Are they going to be consolidated?
Yes, I think under 2112, yes, they'd be consolidated.
You know where they're going to be consolidated?
I think D.C. won the race to the courthouse.
And when are those going to be heard?
We don't know yet. They were just filed. So I see I have one more minute left, and I'd like to reserve that for any rebuttal.
Thank you.